Okay, hi everyone, my name's Rebecca Stadler. We're starting out this month's Pirate Fight Club. We do this event every third Tuesday at noon at our offices at 500 Street, Washington. We usually run for about an hour, but if people have to leave early, that's always fine. And we typically open it up to any questions, and if people are too nervous to start asking questions, then we can just jump in and start explaining the difference of the different types of intellectual property. So does anybody have a question to start with?
Well, maybe you can start with that.
Okay, so I can start. I typically start describing the differences in the different categories of intellectual property. There's copyright, trademark, patent, and then there's trade dress. So those are the different categories of intellectual property that people get confused a lot. So copyrights cover original works of authorship. Some examples that we have in our office are the painting over there outside in the hallway. We've got photographs, copyright attaches to that, and it protects the author of the original work from anybody else copying and reproducing and distributing and selling their work of art. Copyright can be really, really difficult right now in the world with the internet, because it's so easy to take somebody else's photograph from their social media channel, post it someplace else, and it can be very tricky to enforce. So it can be a handful in some cases. Trademark serves to identify the source of goods and services. So if you see somebody walking around with a coffee mug or a coffee cup, paper coffee cup that says Tim Hortons, you know that they probably didn't get that at Starbucks. And then if you see something from Starbucks, you know they didn't get it from Dunkin' Donuts. Ford is another huge trademark, Apple, Nike, those are all trademarks. So they serve a little bit of a different function than copyright. And then patents are they should be easier to distinguish just from the standpoint that they cover inventions. So it's a completely different category of intellectual property. So if you've invented a new air conditioner or with a higher efficiency than other air conditioners, then you would get a patent on that. But then on the actual air conditioning unit, it might say GE, General Electric, so we know that it's from GE and not a different company. And then in that case, there's probably no copyright in anything related to the air conditioner. But if there's a photograph in the advertisement for something, then that would have copyright. So that hopefully makes sense on the different categories.
What's trade dress? Is that a logo?
Trade dress is very similar to trademark. It's the overall look and feel of something. So again, it does identify the source of goods and services. And so if you're driving country roads and you see a tractor and it's yellow and green, we know that the source of those goods is
John Deere.
John Deere, yeah.
We know our tractors.
Yeah. And then
I don't know.
and then if you're in New York City and you see somebody walking around with a shopping bag that's sort of robin egg blue,
Tiffany's.
you know it's from Tiffany's. So that's trade dress. It's the overall look and feel of something. It can be the NBC chimes that you hear, so it can actually be something that you hear. It can be a scent in some cases. It can be a color. That's a trade dress. Trademark is just usually, it's the same thing, but it's usually a word or a slogan.
Is
or an
trade
actual
dress something you
logo.
get the rights to then?
Mm-hmm.
Oh, okay.
Yeah. They do take a little bit longer to acquire than a trademark because they're less identifiable than a specific word or a slogan.
Like that Starbucks mermaid, is that trade dress?
That would be a trademark. That should be a trademark.
Oh, okay.
Yeah.
Because it's printed on things?
No, because it's a logo.
Oh, okay.
A trade dress is more the look and feel of the overall packaging, or when you walk into a restaurant, if it's got a certain feel.
Like, how close does it have to be? What if somebody opened up Tom Hortons? And
Oh, that's a good question. So the standard for trademark infringement, or to obtain your own trademark over somebody else's, is likelihood of confusion. And they look at different things, the strength of the mark, they look at how close the goods and services are, how close the two marks are. And it can be somewhat subjective because one person will look at something and say, no, I don't find that confusingly similar, and somebody else will find it confusingly similar. So we've had trademark applications where the office has come back to us and said, oh, this is so close, we've made arguments and we've overcome it. And then in another case, two trademarks are really close, we made arguments and the arguments don't work. So two different trademark examining attorneys looking at something similar will come to different results.
Okay.
So
then let's say if I had something that was trademarked, who does all the research to find out that there's not a company in California that might have something similar? It just seems so much stuff out there.
right. There are third-party companies that you can hire to monitor it. You can monitor it yourself, but the government won't monitor it for you.
Okay, so it's a matter of by luck? You run into it, or?
Yeah, I mean, if there's a trademark monitoring company doing something, they usually can help you.
Oh,
And they
okay.
charge, you usually sign up for a 1-year-long package. And some businesses use them and some businesses don't. Another way that you can find out is I've had clients come to me and say, oh, one of our customers saw that these people are using our logo
Mhm.
and they were confused and they pointed us to it. So that works out really well because then you've got evidence right there of customer confusion.
Mhm.
So,
Oh,
yeah.
right, because they thought it was.
Yeah, and then
Yeah.
they went back to,
I think an interesting example, I can't remember who gave it to me, but it sticks in my brain with you guys talking about this, was Delta. So you have Delta Airlines and then Delta Faucets. So they both can be called Delta because they're not the same.
Right.
And I was just
okay.
like, oh, I never even thought of that.
yeah, because they're so far away, you wouldn't think that an
Yeah.
airline is gonna start making faucets.
Mhm.
So, there are some exceptions to the likelihood of confusion. There are called, when there's what is called a famous mark, like Nike. So they're in the athletic world. If you wanted to open up a coffee company called Nike Coffee, they're gonna say no, because they're gonna say our mark is so famous that they've got special statutory protections. And they don't want any dilution of their mark, so they don't want anybody opening anything. So there are very few marks that are able to claim famous mark status, but those that can do.
That's interesting.
Yeah.
Because Nike is a Greek god.
But you can trademark anything. It doesn't mean that you can't say the word Nike. You can write a history paper on the origins of Greek mythology and the goddess Nike. You could even write a story about Nike as long as it doesn't give the impression that it's related to Nike.
Gotcha.
So you just can't sell anything under the name Nike. It's really interesting because trademark you do have ownership rights in words, but in a very limited sense, just in the sense that you're selling goods or services under that. So for example, one fellow that most of us have heard about is Donald Trump. He had a trademark registration, I'm assuming he still has it, for the phrase, "you're fired." So we can all still use this phrase if we need to fire somebody at work. Maybe you do it a little bit more delicately than "you're fired," but we can still use this phrase. We just can't sell similar goods and services to those that are protected by the trademark. It's a very abstract area of law, and it takes a long time to understand it.
You trademarked.
I think I was talking to John once, because I have a tagline for my existing business, and he said you could trademark my tagline, so
Right.
nobody else would use it.
Right.
So that's just a phrase too.
Right. Yeah, we have our slogan is defining your intellectual property, and we have that trademarked.
Okay.
And we trademarked Parrot Fight Club as well.
Okay, so anyone who wants to use that, obviously,
Right.
infringing on yours.
Right.
Okay.
I mean, again, if they wanted to open up a coffee shop with defining your intellectual property, they could do that.
Because there's no confusion then?
Because the goods and services are too different.
Oh, okay.
So
Okay.
the goods and services are probably too different. Now, we're gonna argue that they're similar. We're gonna say things like, attorneys are known for drinking a lot of coffee, and people are gonna get confused between our slogan, our legal services and this coffee shop. They're gonna think it's us.
Or that's all you do is drink coffee?
Yeah, that's all we do is drink coffee, and we serve coffee to our clients, so probably wouldn't be a successful argument, but we could try to make it.
Doesn't sound to be a very successful coffee shop.
No, I
It's
think-
a mouthful to say. We're
I
going
think-
down to defining your intellectual property coffee shop.
Yeah, it would not be a very successful coffee shop.
So what does it take to get something trademarked?
You file the federal trademark application, and then you show them that you're using it in interstate commerce, and then they usually give you the registration.
Okay.
And so they'll do a trademark search to make sure that there's nothing confusingly similar. It's already trademarked, and then get the registration and give it to you.
Okay.
Yeah.
How much does it cost to get something trademarked, like a tagline or something like that?
Probably right around $1,000 plus or minus, assuming that there's no resistance from the trademark office. So it is expensive up front, and then for the next 5 years you don't really have to pay anything as long as you don't have to enforce it. And then you do have to come and show continued use of the trademark at the 5-year mark, and you have the opportunity to file an affidavit of incontestability. So nobody can contest your trademark at that point. And then at the 10-year mark, you have to renew the trademark and show continued use, and then you have to do that every 10 years.
Oh, okay.
And the reason that they do that is because the trademark can last forever. Coca-Cola has their registration, they've had it for, I'm assuming, 150 years or so. They're able to keep on using their trademark until they stop using it. But the reason the trademark office wants you to renew it is because they don't want somebody locking up rights to a certain business name and then nobody else is able to use it. So if there's a great tagline out there or a great business name and nobody's been using it for 20 years, you know, somebody else should be able to use it if it's a good name.
Rebecca, can you sell your trademark?
You can, yeah, and all the goodwill that's attached to it,
Okay.
because that's what comes in under your brand,
Okay.
is all the goodwill that's attached to it. So, you know, if you're driving down the throughway, you're on 400-mile drive and you need a restroom and you see the golden arches, you're thinking to yourself, okay, I can pull over and use their restroom. Or a parent with young children driving down the street sees those golden arches and wants a 15-minute break from the screaming children. You know, put them in the playground, get a cup of coffee, and then you get a little reprieve. Or a health food nut would look at those same golden arches and think, I'm staying away from this place, I don't like the fast food, and this isn't good for me. So Nike's the same way. You look at that little swoosh, and some people are thinking, oh, this is a great, amazing product, hide all the technology, and then somebody else, maybe they've had a bad experience with Nike and they don't like their products, so they use a different pair of sneakers. So all the goodwill that attaches to that is what you can sell, and your trademark can be extremely valuable and extremely powerful.
Okay.
Yeah.
And any slight modification, adding an S to it or anything like that is a new trademark? You can't update your trademark, or? It would depend on the specific trademark. You're probably, because the trademark covers your mark and something confusingly similar, you're probably indirectly covered for the modification. Okay.
But if you're using it 2 different ways, you're probably covered by one trademark. But if you stop using it the way that you've trademarked it, and you move to a different use, then you would want to trademark that, because the other one you're not going to be able to renew and show the trademark office that you're still using it if you've changed the way you're using it.
Okay.
So when you register a trademark, you have to select how you'll be using it? So like different categories, I assume?
The categories of goods and services.
Okay.
Yeah, you need to do that. You also need to decide if it's a logo and you're not sure about the color. We usually recommend filing it in black and white. And then that covers any color combination. And that can be helpful for a business that around St. Patrick's Day, let's say they start using a green logo instead of their blue one. That would be covered if it's just black and white. But for the most part, if you've got sort of a couple variations of the business name, you will want to settle on one before you file the application, because it's expensive to file them. And so we've got some clients that are big companies, and they want to lock down the rights to a couple different names while they test market the names. They've got the money to do that, but for an individual startup company or something, you usually don't even have the money for the trademark at all. So filing more than one application is, probably not what you want to do.
So if you started a business and it's starting to take off, you would probably then want to, or do you do it before you start?
My recommendation is to start it beforehand, only because as soon as possible, basically, because with the internet, it is so easy for somebody else to see that name, take that name, start a business in another state, and then maybe even go to the trademark office before you get there.
Okay.
And then they get the trademark registration. We've seen that happen before.
Now, Rebecca, we're so close to Canada. Like, do you see a lot of people here in Buffalo also doing things in Canada right away?
Maybe not right away. I think it depends on the business. If they know they're going to go into Canada, they may file a patent application up there, or they may file the trademark application up there within 6 months or a year. The patent deadlines are a little stricter. But yeah, patent. I just changed the name of Canada to patent. Canada is really close, and so in some cases we do have clients that file things up there. We have a relationship with a law firm up there as well.
Oh, okay.
Yeah, so we'll kind of take the work and explain to our colleague up in Toronto.
And the prices, they are about the same, or is Canada a lot higher? Or?
Canada's probably a little bit cheaper, and then I think the dollar
okay.
is a little bit stronger, so we've got that advantage too.
Okay.
So
Okay.
yeah, and it's just Canada's a market that's 10% of the United States, so their government recognizes that, and I think their filing fees are a little bit lower,
Okay.
but not a lot lower, but
Okay.
a little bit.
What about if can you combine a logo and a tagline and make it one?
You can do that. We usually recommend not doing that because then your trademark really just covers that combination. So if you ever separate them, then they're not really, it's not really covered.
Like if you change your tagline or, okay.
Right, or if you change your logo, or if you just start using the logo and you drop the tagline, then your trademark registration covers the combination. So we usually recommend not doing that. In some cases, that might be the way to go to keep costs down, so we're not all Nike with millions and billions and trillions of dollars that we can trademark everything. So in some cases, we have done that for clients that combined.
So if we have a client who wants to patent something, or they have something they think they want to investigate working on a patent, what's the cost for that? Do you do that like on a retainer? Is that an hourly, or how does that work?
We do project-based pricing for patent applications. And then in the patent world, there's something that the United States has that's kind of really, really good and kind of really, really bad. It's called a provisional patent application, which
I've done already.
Yeah, which Kathy's done. And so the upside is that it gets you an international filing date, so that the filing date is recognized in all the international countries. The patent protection will end up only existing in the United States unless you do file in the foreign offices. But the upside is it doesn't have all the legal requirements, it doesn't need to have patent claims. The drawings can be informal, so you basically describe your invention as thoroughly as possible, file the application. The legal fee and the government fee is lower than it is for the non-provisional, and that gets you the filing date, and it buys you 1 year to file the non-provisional.
Okay.
So the upside is the client can go out and they can market it as patent pending, they can try to sell it, they can see whether there's market interest, and they haven't spent the large non-provisional legal fee up front for something that maybe isn't going to work out. So there are a lot of benefits to it. It's a little investment. You did the market tryouts and nobody's interested, or oh, it's good, but maybe make some modifications. Then you can file the non-provisional and make some of those modifications if that makes sense. The downside is that year goes by really quickly.
5 years goes fast.
Yeah, you sort of sneeze and then.
That's why I'm here.
Yeah, and your non-provisional is coming due. And then, of course, the patent attorneys need a little bit of time to write the non-provisional from the provisional. So we usually start sending out reminder letters around the 8-month mark when there's 4 months left. So a year goes by fast and 8 months goes by even faster. And
Are you bound by the language or the terms that you use in your provisional?
no, if there is a huge difference between the provisional and the non-provisional, in some cases, if there's a huge addition, we'll file a second provisional within that window and then claim priority to both of them from the non-provisional. But yeah, so it can be, the provisional is very beneficial to startups and independent inventors who aren't 100% sure that they want to dive straight into the non-provisional pool. The United States is actually the only country that has provisional patent applications. So it's a benefit to start up businesses and independent garage basement inventors. So it can be really beneficial. I think in some cases people think, oh, I've got my provisional on file, I can party a little bit and then get back to work, and they party more than they realize that they should have, and then at the 1 year they haven't really done enough, and so they can't even make an educated decision on whether to file the non-provisional because they didn't do enough work. So then they're just right back where they started. Yeah.
But what's good about it is you can put that patent pending on your packaging.
Oh,
so that
okay.
it deters people from copying it because they know that you're in the process of going through all that.
Right. And they don't know, but when it says patent pending, you don't know if it's provisional versus non-provisional. They have no way to know that, so.
It just means something's happening.
Yeah.
Mm-hmm.
Yeah, and it lets the reasonably prudent business person know that you're taking steps to protect your intellectual property and that you're aware of your rights, and hopefully they stay away.
Right.
For me, part of my blossoming business is blogging and blogging.
Okay.
So at the end of the day, it's just my story I'm sharing, useful resources. It's in my own words, so more so just learning. I'm here to learn what should I be trying to protect, or what maybe I should not put effort into and what I should.
For so everything's on a web page. So everything that you write and all the videos that you create, that's all copyrighted.
Okay.
So it has copyright protection as soon as it's in a tangible form of medium. So in this case, on the website. So copyright attaches automatically. In the event that you ever need to sue anybody, you could register your works with the Copyright Office. The other thing that you can do in some cases is if you've got a series of, for 2018, you could file a copyright registration that covers all of those blogs. So 2018 blogs, and then maybe at the end of 2018, you could also do 2018 vlogs with a fee. And do 2 separate ones to cover all of those as opposed to doing them individually.
Okay.
So for all of those things, copyright does attach, you do have protections. The hard part is if somebody, there's 2 things I want to say. The hard part is if somebody else tries to take one of your posts and uses it as their own, then they've infringed your copyright and you may want to try to go after them somehow. The other thing to do is to be very careful when you're writing the blogs to not infringe somebody else's intellectual property. So In some cases, if it's a fashion blog and then they take a photograph from a runway, one of the runway events, and they use it in their blog, there's the potential that they've infringed somebody else's copyright.
Yeah, so far when I've run into using other people's stuff, I've been making sure I get them credit directly to their website or where the information's coming from when I can. Actually
Right.
asking, hey, can I use this?
Yeah.
So that's what I'm trying. I don't want to steal anybody's stuff, but some stuff is so good you have to share it. But I like to let people know this is not from me.
Yeah, I
This is
think
from her.
the best way to do that probably is to not have the image or the quote or the article in your actual blog, and say if anybody's interested in seeing this photograph, click here, and then it links to their blog,
Okay.
because then it's not you that's showing the image, it's them. That can be, excuse me, a little bit less interesting because you can't put the image there. So that's what we do, we ruin days. Intellectual property attorneys ruining people's days.
If you have a blog, it's automatically copyrighted?
Anything that is an original work of authorship has copyright attached to it as soon as it's in a tangible form of medium. So if you're sitting here and you write a poem, then copyright attaches. What that does is it gives you a bundle of rights. The right to copy it, to distribute it, to reproduce it, make derivative works. But what it doesn't do is it doesn't really give you the right to enforce your copyright against somebody else. That's where the registration comes in.
Okay.
So you register it with the Copyright Office, and then if you need to sue somebody or send a cease and desist letter, you could do that.
Okay.
So for a lot of my artist clients, I'll say to either do a series where you've got an entire quarter of the year, half a year, the entire year of your photographs, let's say, and copyright them all at once. Or I had one client that they just had a bunch of metal sculptures, and they had one that was near and dear to their heart, and they copyrighted that one. So the rest they didn't worry about, they just really wanted to copyright this one work, and that's what we did.
Right. The one thing that I discovered just doing the logo part of it is I had no idea that certain fonts and typefaces you have to buy a license for. And that, if you're selling the product, if the product is for sale, like let's say you put you use somebody's text on this, their font, and then but you're selling this, that some people will go after you
Right.
for the license to use that particular. And if you use
Gotcha.
it in something that you're not selling, you can go online on all those font and grab them. They're free,
Right.
free. But as soon as you put it on something that is being sold,
That's where it gets.
that's where it gets a little crazy. But you got to look at all of them, and if you can see the fine print, like no license required, it's crazy.
Yeah.
Things
Yeah,
like
that's
that.
another thing on your blog or your blog, to try to stay away from any music snippets.
Yeah.
Sounds
So
like
I
you're
actually
doing
have original music for my intro.
Oh,
It's
okay.
me,
Nice.
so they can't sue me because I know it's me.
Yeah.
And then some of my teachers have given me like sites where you can go to use stuff for free, and it's like guaranteed, like you can use this
Yeah.
music. There's this one song I want to do a motivational video to, and it is not free, so I'm actually contacting the artist's team to ask for permission to use it because it's not, I don't want to sell it, but I love the music and I know I have to use this, so I'm waiting to hear back from them.
Great.
What about if you put on your Facebook page stuff? If that's where you post your things? Is that owned by Facebook?
It's still owned by you, but if you read the terms of the Facebook licensing agreement, you've licensed them, let's see, an irrevocable, royalty-free, transferable license. So it can be very tricky when you put stuff up on Facebook. So if you put your photographs up there and somebody else uses it, it may be hard to enforce them to not use it.
So you
'Cause
could
it's on,
You could link something else to Facebook, but it's best not to start the post from Facebook? If I'm putting an article or something like that up.
I think you can put an article on Facebook. What do you mean an interesting article that you found?
No,
you
that I wrote.
Okay.
So like if she shares it from her blog instead of just creating it solely for Facebook.
Yeah, it might be better to put the link there, to
Okay.
sort of have an intro and then the link,
Okay.
so that people can go out to your.
The cool thing is I've done that, so when you do put the link in, it gives a little summary of what the post is about, and you can put a picture, so it's kind of like appealing looking.
Okay.
Right. And make sure that the picture that you use is in the public domain, so that you're not infringing somebody else's copyright on your Facebook page.
Yes.
That would not be good.
No.
I usually try to just make a cover title, just a title of whatever it's about, and then that's the photo.
The other thing I can talk about that's sort of timely is the Super Bowl trademark. So you know you can't have a Super Bowl Sunday sale. You have to have a big game Sunday sale because the NFL owns that trademark, and they are very, very diligent about protecting their intellectual property and
So
their
that's why I
brand.
went to see game day on the
Yeah,
commercials.
yeah. I actually recently saw a local business have, Super Bowl sale, and I was thinking, how did you not get caught yet?
Well, do they have like people that are just out and about finding this stuff? Like how, like you would think a little mom and pop little store.
A mom and pop store probably would kind of fly under the radar, but the bigger stores like True
Like a
Value
Macy's
or
like
something,
that, yeah.
right? Or sport like,
Oh,
The
definitely.
Kibachis have Super Bowl Sunday special, or they have to call it game day special?
yeah, big game special,
Okay.
yeah.
Well, they went after that church that was doing a fundraiser a couple years ago.
Really?
It was a church fundraiser.
That's heartless.
Yeah.
And we're pretty surprised.
But they've got this big brand and they've got a lot of sales behind it, and the problem with not enforcing their trademark is that then the next person that infringes it can say, oh, but you didn't enforce your trademark against these people. And so you're showing a pattern of inconsistent enforcement, and so yeah. So in this case, the NFL doesn't have much of a choice. If they find out about it, they've got to enforce it.
It happened to me. I'm just putting this out there. If you're at the wedding and you have music in the background, like people dancing or something,
yeah,
they
that's
pulled.
true.
They pulled. I had a Prince song in the background of people playing, and his particularly when he was alive,
Yeah.
his legal team like nipped everything, and they
Yeah.
caught it and they took all the audio off and I was like, that just looks weird. It's just
Yeah.
people dancing
Dancing to that
randomly.
video. That's true.
And it's just like, in that case though, is there anything, like a wedding where obviously you can't control the music, but if you give it credit, is there any way to like give them credit where they don't stop you?
No, giving them credit is usually not enough. Yeah, but you didn't get the license from them.
Okay.
So, yeah, so that's unfortunately what you need is the license to use the
That's
music.
good, remember.
You can't just
Yeah.
say music being provided by DJ Money or whatever?
Well, the license extends to the DJ, but not from the DJ to anybody else because it would be most likely a non-transferable license.
So you couldn't just credit the DJ and have that count?
Right.
Okay.
no.
Then do you have to do something where everyone going to the wedding our wedding's gonna be on social media, and do you have to sign something like this to say you're okay posting a picture of you online? Like how?
You're asking an intellectual property attorney to that question. You already know the answer. Technically, yeah.
Yeah.
If it's going to be used in the form of advertising, if it's just a news report that shows something that happened. So, for example, let's say there's a big, if there's a model walking down the street and the newspaper takes a photograph of that person and says, oh, this person was in New York City today. That's considered news and that's okay.
Oh.
But if, like Prada, the brand Prada says, oh, look, this model is walking down New York City wearing Prada today. And Prada does that, then that's considered advertising and they need consent
Because they're
from.
making money on that picture.
Right,
sale.
theoretically.
Okay.
So,
So if it's just Jack and Jill's wedding and it's Jack and Jill's social media accounts, that's okay. But if Mimi were to take it and say, here are some examples of weddings
right.
where I worked, and you want to show those blips, you should have releases from the people who are
That
in
are
those
actually
images.
in that
Right,
image.
yeah.
So I know that I want to eventually be an LLC. Right now I'm a team of one. So I'm like sole proprietor sounds much better.
Well, you can be a sole proprietor LLC.
Okay.
The
So, yeah,
LLC has some nice benefits because it separates out your liability. It allows you to keep your finances separated.
Yeah, we need to do that.
Yeah, and then you can, there are so many expenses if you talk to an accountant or a tax person. There are so many things that you're probably using your own money for that should be coming out of the LLC.
Okay.
It might even be the case that the first year of your LLC, you actually have a loss. So that's actually good from a tax standpoint.
Okay. And then also, like when I get up to the trademarking and everything, I think that stuff is going to take me a little bit more time because I don't have any money.
Yeah.
So it sounds like from what you're saying, the biggest thing is just knowing that if you're putting stuff out there and it's not trademarked, someone can have a chance to try to take it.
Right, yeah.
Okay. I need to get some trademark money.